because I wanted it, even though I didn't want to convict him, I thought, well, I'm going to try that fucking case in New Jersey and just reinstitute the back ones. The second one, second sheriff.
One turning 16 and one turning 12. So the two younger ones are home at my house now. So the 20-year-old goes to home garden up to the
Oh, okay, great. But they have to keep tabs on the kids that girls. They run running down your own. They have you running with the parents, don't they?
Absolutely. My oldest one just milked it this morning.
It's wonderful being here.
And I'm mad at her for it. And of course
Not for long. Not for long. I have one son, and between my family, we have 4 kids.
How old is your son?
He's 42. Hard to believe.
I just want to get my daughter out of her 20s. The 20s is when I start really wanting.
Well, even with boys, I didn't know this. And then once he got married, he was late bloomer. I think he got married at 35. He was on. And now he's
I think that's better.
It is actually better.
When I get a lot of they plan weddings like literally the week after that. But I'm just
hold on. Whenever.
You know, but everything has to be all their friends are getting married, they feel this pressure. You would not have liked I would come to court and take it out. So my oldest, she was a senior in high school. So I went home and changed after court before going out. I came home for lunch, which wasn't unusual for seniors and done things. So then I noticed she was putting the dog in the basement. I'm like, what's going on? She's like, oh, my friend comes by, he buys some food. So I didn't think much of it, so I'm about to leave. And then I see this little and he was walking in my house to go out, and he didn't see me in my car. So that's when I
so it can be addressed.
And I felt terrible.
On the next day.
I didn't pursue it. I was like, yeah, 5 minutes. But that was my mentality back then. I was just
Oh, so you want the August 29th date canceled? And what's it on for August 29th? Like I said, my session is and there's no work is.
Am I going on for July 5th?
He won't be back till Thursday. When are you going to be? What? Yeah, good.
July
so
5th
go.
One.
And you're on vacation. You're on vacation till when? All right. So I'll take it off. I'll take it off. All right. And text the let her know that it's going to be off.
That's great. Let's make sure it's
Okay.
Okay.
Okay. Have a good vacation. Bye. Andrew.
This honorable court is in session. Please be seated.
Good afternoon. We're on the record of Commonwealth versus Aaron Hernandez, docket number 14-10417, and docket number 15-10384. Can the parties please identify themselves for the record?
Good afternoon, Your Honor. Patrick Hagan for the Commonwealth.
Good afternoon, Your Honor. Teresa Anderson for the Commonwealth.
Good afternoon, Your Honor. Janice Smith for the Commonwealth.
Good afternoon, Your Honor. Jose Baez on behalf of Aaron Rodriguez.
Your Honor, making my first appearance, Linda Kenny Bodden on behalf of Aaron Hernandez.
Alex Spiro on behalf of Mr. Hernandez.
Good afternoon, Your Honor. Robert Proctor on behalf of Aaron Hernandez.
All right, good afternoon all. We have a motion the Commonwealth has filed, a motion in limine for an in-court identification of the defendant. Mr. Baez, you don't practice in Massachusetts, but I'm sure you're becoming familiar with Mass law. And the motion before the court relates to a recent appellate decision, Commonwealth versus Creighton, requiring good reason for an in-court identification where there has not been a prior out-of-court identification. Are you familiar with Creighton?
I am, yes, sir, Your Honor. I read it just prior to our last appearance.
And as I understand it, Mr. Hagan, you're filing this motion as it relates to one anticipated in-court identification that was not subject to a prior out-of-court procedure. Is that right?
Essentially, Your Honor, I think arguably you could say there was a prior procedure as this one witness did view a surveillance video and identified himself and the defendant. But yes, generally it does fall into the parameters of Creighton and Collins.
No, and that relates to Mr. Bradley.
That is correct, Your Honor.
All right. You don't anticipate eliciting any identifications from any other witnesses who were not subject to some out-of-court identification?
Just to clarify, it would be witnesses to the actual incidents that I think is what's covered by Creighton and Collins. And the Commonwealth would not be seeking to introduce any other in-court identifications of any other witnesses other than Mr. Bradley.
As I recall it, this is an incident where there were several others in the vehicle where the two named victims were located. You do not intend to elicit identifications from that?
In-court identifications, no.
All right. Now let me ask, does either side see a need for an evidentiary hearing on the motion that was before me?
I would like an opportunity to file a reply motion because I think while there's no issue to the technical aspect of specifically IDing one person, I think we may have an issue as to the motion does encompass allowing those witnesses to give their descriptions of who they believed. And based on what I've read so far, those descriptions have changed over time. Specifically, once it became public that Mr. Hernandez was, in fact, the suspect in this case and then subsequently indicted, I think we might have an issue with that. I'd like the opportunity to explore that. I was going to ask the court for 30 days to respond and then basically take it from there instead of for hearing. But I do anticipate us litigating the ID aspect at some point. And if I may make a correction, Your Honor, my mind is still in Florida. My client is Aaron Hernandez, not Rodriguez.
All right. 30 days would be enough time for you to have something filed with the court?
Yes, sir.
Then why don't we set Friday, September 16 as a filing date for any defendant's reply or memorandum of opposition. Given that we are only dealing with Mr. Bradley, and as I understand it, Mr. Bradley had some significant relationship to Mr. Hernandez, I don't know that this is going to warrant some evidentiary hearing on the identification issue. But let's see what you filed, and then we can determine that.
Thank you, sir.
Now, Mr. Baez, at our hearing last month down in Plymouth, you indicated you intended to spend, up until today, becoming more familiar with the case, the ins and outs of the case, as it relates to further pretrial activity. Tell me what you envision.
As it relates to pretrial activity, one of the concerns that we have that we'd like to try and resolve today, if possible, is set a witness list and exhibit date so that we could see if there are any potential issues down the road as it relates to some of the discovery. Now, I've cracked a major dent. I'm around page 20,000, but there's still some more to go. Not much. And from what I see currently, there are numerous directions that the investigation takes us to. We're talking at least 2, maybe 3 crime scenes that would involve certain issues that may arise both in forensics and factually. So I'd like to see if the state has narrowed their specific case in a way that we might be able to eliminate certain irrelevant factors as it relates to the case, or what we deem to be irrelevant, of course. So I think if once we had a state witness list, and the exhibits can certainly come a little bit further down the road, but once we had a state's witness list that we knew, okay, we can discount these individuals and discount this situation, and focus specifically on this, I think I'd have a better understanding for the court as to the rest of the pretrial litigation. However, what I know so far, again, we're still waiting on the appellate court ruling for the phone. If that comes back adverse to the defense, there might be an anticipated follow-up motion to that.
What sort of motion? Is that a motion relating to further activity with the phone, or is that a motion relating to how the government came to know of it?
Exactly, how the government came to know the phone.
So I take it to under the umbrella of a motion to suppress or a motion to exclude. So.
Correct.
Right.
Then I believe we have already begun discussions with the state in reference to setting up a evidence inspection of all of the evidence. I realize we may have some issues as it relates to the Palm Beach incident. Florida has very liberal public records laws, so whether some kind of coordination in conjunction with the public records laws, my understanding is even CNN has gone down there and inspected the evidence, so I don't anticipate that being a problem. Having said all of that, there might be some issues, whether we have any Daubert issues or anything like that. It's too soon for me to say. However, overall, looking at the grand picture of things, I think once we get a witness list, that would be a good start. Follow that up with our evidence inspection. Wait and see what happens with the appellate ruling. But I'm all for, and I understand the court's interest in moving this thing along, and we're certainly full speed ahead. So whatever the guidance the court would like from us, I'm more than happy to answer that.
Well, I've heard from what you told me, there's a potential motion to suppress as it relates or to exclude the cell phone. And I can understand why that's not filed. That depends on what the Supreme Judicial Court is going to tell us about the cell phone and the Commonwealth's right to access. So let's put that aside for one moment, because obviously you can't do anything about that until the SJC is handled steady. We talked about potential trial-related motions relating to the type of evidence that may be presented, and potentially Tobert motions challenging either the science or qualifications or methodology of some expert. And that typically is something we will see at or around the time of trial. So let's put that aside for a moment, as well as what at least in Massachusetts are routine trial motions. Motions in limine, motions to remove evidence, motion relating to bad activities, things of that sort. As to the Commonwealth's submission of a witness list, normally we see that at or about the time of the final pretrial conference, which normally takes place about 2 weeks before the trial date. So that doesn't give you a lot of time to anticipate and react to those witnesses the Commonwealth intends to call. Mr. Hagan, what is your view in terms of trying to help Mr. Bias understand the scope of your case?
Yes, Your Honor. As the court stated, technically speaking, we would not typically give a witness list or exhibit list until the final pretrial, but I have engaged with some associates of Mr. Baez with some preliminary conversations, and we would make every effort to assist the defense team in narrowing down the evidence. We can produce a witness list for them of potential witnesses. My concern is that that would be upwards of probably close to 300 potential witnesses. So what I have offered, at least
help a whole lot.
Exactly. So I have offered certainly to Mr. Baez's associate, and I would offer to them as well, as we can certainly engage in conversations and be helpful in the sense of advising the defense team which witnesses are likely to be called, which witnesses are not likely to be called. We're certainly willing to do anything to assist the defense in being adequately prepared.
Sure you are. Mr. Baez, at least if you get an indication of what witnesses the Commonwealth is taking off the table, that may help you to understand categories of evidence or acts that they don't intend to pursue. That might be helpful. Now, when you say you've had preliminary talks, Mr. Hagan, have you all sat down together yet?
Not yet, Your Honor, not all together.
Have you arranged yet a time where you would sit down and review evidence?
We have discussed doing that, but have not picked a date yet, Your Honor.
What's reasonable for that?
For the evidence, the local evidence inspection, Your Honor?
Yeah.
I'd like to do it within the next month or so. I'm going to check my schedule. That was our plan, to check schedules and see. I'd like to try and move that along fairly quickly.
You do that in the next 2 or 3 weeks?
Yes.
Mr. Hagan, are you around?
I am, Your Honor.
And is the squad around to make the evidence available?
Based on my conversations with them earlier today, I believe they are. And this is something that we could arrange within a few days.
All right. Well, why don't we say that is to occur within the next 3 weeks? And I'll leave it to you folks to pick out when that occurs. And if you're sitting face to face, then you can begin to discuss what the Commonwealth's case might look like, or at least help Mr. Baez to understand what you won't be focusing on. All right. Mr. Baez, do you see any substantive motions? We've already dealt with motions to suppress relating to vehicles and home searches, I think. We've dealt with a motion to dismiss relating to the grand jury proceedings. It seems to me that's all been resolved. What do you think?
If I may touch upon something, I think the exclusion of back to the witness list issue. I apologize for bringing that up. I just wanted to make this point, if I may. I think that's a great start for us, for them to let us know who definitely they're not going to call, and then we can eliminate that. But what I find different with these types of cases, when I say these types of cases, I mean those that reach a certain amount of notoriety in the press, is that there becomes a lot more paper. A case like this, I could anticipate if it being somewhere definitely under 1,000 pages of discovery. However, once something hits the news cycle, the investigation accelerates, and they're knocking down trees like a lumberjack. So, based on the sheer volume that this investigation has taken us from Massachusetts to Florida to California to New York, there's all different types of things going on with this case that I do think setting something or accelerating the date of a witness list is critical to us being able to effectively represent Mr. Hernandez. So I don't want to beat a dead horse on that issue, but I couldn't stress its importance. Now, in furtherance of answering your question, as far as substantive motions, I think Your Honor's covered a majority of those, but until we've gone through it all and inspected the evidence, I wouldn't want to make a representation to the court and then it not be accurate. But
Well, and that's why I gave you, since the last hearing,
yes,
to think about what it's going to be so that it can be accurate.
I think there may be certain substantive motions that might be filed.
There may be what?
There, if I may have a moment here. Yeah, he's all right. He's all right. Yeah, he's good now. Speak up again. Yes, sir. I can tell you that the court has pretty much covered a majority of what we anticipate. There may be a revisiting of one issue in the event that we discover something that was not previously argued as it relates to the jurisdictional issue.
That's relating to the intimidation.
Correct, correct. I realize the court's ruled. We respect Your Honor's ruling, of
Okay.
course, and if
So
there's something...
possibly a motion to reconsider as it relates to that issue.
And I would only do that if we found new grounds or a different argument. I wouldn't waste the court's time.
That's fine. All right. What else?
That would be everything that I can think of at this time.
As to a trial date, folks, if you all looked at your calendars, I had indicated that I would have liked to try it in the fall, beginning maybe October, November. Mr. Baez, you indicated that seemed too soon for you to become fully familiar with the case and have it in a position where you wanted to proceed. You suggested next spring, which I indicated was too far, too long. So splitting the difference, that might take us to the beginning of the year, January or February, recognizing the difficulty around the December holidays of seating a jury and having a jury try and conduct business through Christmas and New Year's. If we were to look at an empanelment right at the beginning of January, is that feasible for both sides? Commonwealth?
Feasible for the Commonwealth.
Bias?
I think that would be way too soon for us, Judge. Having the sheer number of work that we have to do to effectively represent Mr. Hernandez.
Well, yes, but you're not starting from scratch. You're starting from a pretty solid base.
I understand that.
Mr. Rankin himself.
And I understand that completely. I'm just anticipating, first of all, we're going to have unique jury issues as well, given the publicity, given the prior case. I think that may also require some litigation prior to even impaneling a jury. And speaking before having inspected the evidence and what forensic issues may come up, I don't want to make a representation to Your Honor and not be able to comply with it. I want this court to know that when I make a statement before Your Honor that you can rely on it.
Okay. And similarly, I'd like you to be able to rely on what I tell you.
Yes, sir. Well, I think you've got the final word, so.
Yeah. Let me seek counsel. It's yeah. counsel, hearing from all of you as to your commitments as to what remains to be done, and understanding a number of attorneys are involved in professional activities in early January. I will set a trial date, but consider this to be a very firm trial, February 13, 2017. Mr. Baez, I don't know if you're familiar with Rule 36 of the Massachusetts Rules of Criminal Procedure, which is our statutory speedy trial clock, and it permits or tolls periods of time from the speedy trial calculation based on either agreements between counsel or defense requests or acquiescence to delay. It seems to me, for all the reasons that we've discussed, it is appropriate to toll any period of time between now and February 13, insofar as you are benefiting from the time and indeed requesting this delay to become fully familiar with the Commonwealth's case and to prepare the defense. Is that appropriate, Your Honor?
Yes, Your Honor.
The period of time from today to February 13 will be told for purposes of Rule 36. February 13 will be the first day of jury enactment. Now, I'd like to set a date, perhaps the beginning of October, for
October 3rd.
Wednesday.
October 5th is the first Wednesday.
I'd like to set, if it works for you folks in your calendars, Wednesday, October 5, at 2 o'clock. For a status hearing, for a report as to the evidence inspection and any issues that may have arisen in that. And as a filing and, if possible, hearing date on any defense motions for further discovery, for further forensic testing or examination, or any other pretrial motions. If you're contemplating a motion for reconsideration, is that something you could have filed by October 5, Mr. Baez?
Yes, sir, it is.
On October 5, to the extent you're not satisfied with what the Commonwealth's told you as to how they anticipate the case being tried, that is, telling you which witnesses at least are off the table, we can address that on October 5. All right, is there anything else we can do today?
Just so I'm clear, it's the court's understanding that the state and the defense will discuss elimination of witnesses, but yet not have a specific date in mind for a witness list until, well, I guess that's to be discussed on the 5th.
Not at this moment. If you're not satisfied with what they told you, I'll hear you on October 5.
Very well.
Bear in mind, that still gives 4 months for you to become aware of what the Commonwealth's intending to present and prepare whatever challenge may exist. like to be able to focus and hopefully rule on any further requests for discovery that you may have based on what you've seen, to at least schedule a hearing, if appropriate, on a motion for reconsideration on the motion to dismiss, and to be at least have filed, if not heard that day, any further or any motions for independent forensic examination. And I think that would cover, if further hearings are needed with regard to those motions, then we can set that date on October 5. We can also set dates for the filing and hearings relating to trial-related motions and petitions. Okay, anything further?
Nothing from the defense, Your Honor.
Nothing further on.
All right, Mr. Baez, I'd be happy to have Mr. Hernandez here on October 5.
Yes, sir.
Would you like his presence?
Yes, sir, we would.
Very good. All right, we'll see you October 5, 2 p.m.
This matter is a September 16, 2016 out-of-court filing date for the opposition of the out-of-court, in-court identification. There's a presumptive trial date or a firm trial date of February 13, 2017. And the next being court on October 5th at 2 p.m. in courtroom 808. That's going to be for a status of the report of the evidence inspection as well as filing of discovery motions and forensic testing. Mr. Hernandez will be paid on that date.
All rise, please.
8? August 8th?
No, courtroom 808.
I was gonna say, what?
All right, 10-5, we're going to proceed.